Legal environment in starting a venture in Indonesia. Why is legal environment important? Legal environment acts as an important factor for setting up or running any business activities by an individual or any organization in a particular country. Legal environment decide the way of how businesses activities of any particular country are able to flourish or may get constrained by the laws of the nation. It also influences in estimating the useful economic life of an intangible asset. The legal environment of business. The business environment is based on a set of conditions, such as social, legal, political, economic, and institutional conditions. Internal environment. The internal environment usually includes manpower, capital, machinery, raw materials, and last but not least is management. Those are generally controlled by the business internally. If the governing body of the business wants to change the policies, they can change its function and go forward to develop its profitability. External environments. The external factors of a business firm are beyond the control of a certain enterprise. Governmental policies, tax, legal factors, political factors, social events, economic functions, and also geological factors are the main external factors of a business.
What is legal environment of a business? Legal environment of a business refers to the strategies adopted by any government to help, manage, or constrain the business ecosystem of the country. Dimensions of business law environment. There are 5 dimensions. The first one is economic environment, where it includes rate of inflation, demand and supply, and economic policies. The second one is social environment, which includes culture and traditions, social trends, and values. The third one is legal environment. The fourth one is technological environment, and the last one is political environment. How do legal environment effects on business? The legal environment do affects the activities of a business. If the legal environment runs properly, the business can touch its actual profitability point. The investors will feel secure if the market properly follows the business ethics. The legal environment is one of the major things to attract foreign investors.
Government laws and regulations include contract laws, consumer protection laws, employees protection laws, health and security laws, and security against termination. How to set up a PT? First, you need to prepare data for the establishment. You also need to name the PT company, place and location of the PT, and the mission and purpose of setting up a PT. Things you need to consider while determining mission and purpose of PT must not be business forbidden by the government and business license depending on the business itself. And the last thing you need to prepare is the capital of PT. The minimum capital of the PT is 50 million rupiah, and a minimum of 25% of that capital should be put into the company immediately. Based on the new regulations, minimum capital will be decided between the founders. Deed of establishment at a notary. Any notary, as long as it is registered at the Ministry of Law and Human Rights. All of the PT founders have to sign the draft of the PT establishment in front of the notary. If a party is unable to be there, then that party can give power of attorney to another person to sign the draft on his behalf. Decree of Ministry atau pengesahan akta. Ministry will give the decree that state that the PT is now legalized and a legal person. A rights and obligation registration tax number atau NPWP.
Okay, so for the next step, there's domicile of PT. So domicile license is issued by kelurahan, surat keterangan domisili perusahaan. And then the requirements usually cover letters from the RT or RW, and then PT's founder's ID and deed of establishment. And this is usually applicable for 1 year and also could be extended. So next, the PT has to obtain a registration tax number, which is MPWP. So MPWP is a surat keterangan terdaftar pajak, tax registered certificate. And the next step is business permit, which is they need to get surat izin usaha perdagangan And also SIUP, micro, kecil, menengah, dan besar. And lastly, they need to get BPJS, which is a social health insurance. So they need social security administrator for employment, register the PT's employee paid by PT, and ID cards and KK of the employees. So the requirements for setting up a PTPMA, which is penanaman modal asing or foreign investment company in Indonesia. So first they need to pay up capital, which is the minimum paid up capital for a foreign-owned company in Indonesia is 10 billion. Shareholders will have to sign a capital statement saying that the shareholders have sufficient funds for the capital requirements. And second, structure of a foreign-owned company in Indonesia. Shareholders or every limited liability company in Indonesia must have at least 2 shareholders. They can be individuals, corporate shareholders, or both. So why you should choose PT or PTPMA? So in Indonesia, your PT company will have the highest chance of surviving. For starters, you can easily raise money by giving investor more company shares. Second, the shareholders mostly choose how long the leadership will last. The existing leadership may be reviewed at the meeting of these shareholders. Last but not least, your business won't focus on a single major line of business, and actually you are free to get into 3 major business sectors with your PT company as you see suitable. And so, however, for the PTPMA, your foreign investors, you have the options of choosing PTPMA structure rather than a pure PT. In English, the PTPMA firm is referred to as foreign investor company, and this implies that you, the foreign investor, are eligible to hold 100% of the business, and this enables you to enter a few specific business sectors.
There are a couple differences between PTPMA and PTPMDN. The first one is that PTPMA is a limited liability company with foreign direct investment ranging from 1% to 100% foreign shares, whereas PTPMDN is a company that's a limited liability company with 100% local or domestic direct investment. The second difference is that PTPMA has shareholders that are not legally liable for company liabilities, whereas PTPMDN has shareholders that are not legally liable for company liabilities. The third difference is PTPMA has a minimum of 2 shareholders, individual and or entity, 1 director and 1 commissioner, whereas PTPMDN has a minimum of 2 local shareholders, individual or entity, 1 director and 1 commissioner. The third difference is that PTPMA is a foreign individual that can become a director or a commissioner, whereas PTPMDN is a foreigner individual that can become a director but not a commissioner. The fourth difference is that PTPMA has a minimum authorized capital and paid up capital requirement is 10 billion Indonesia rupiah, whereas PTPMDN has a small of 1 billion till 5 billion Indonesian rupiah, medium 5 billion till 10 billion rupiah, and lastly the large is more than 10 billion Indonesian rupiah. The last differences between PTPMA and PTPMDN is that in PTPMA, foreign employees are allowed to work in a PTPMA, whereas in PTPMDN, foreign employees are allowed to work only in medium and large-sized PTPMDN. So the conclusion is that legal environment focus on legal ethics, contract procedures, court procedures, consumer law, torts, property law, environmental law, and employment law. The legal factors of a business affect the business environment as a consequence of direct relation to government laws. If we want to make a healthy and stable economy in our surroundings, we should care about the legal environment of business.
Here are the resources we used to create the presentation. Thank you.